Hi everyone, my name's Mandy Fredericks. I'm an attorney at Squires, and I'm going to lecture you on legal costs today. Legal costs is a ridiculous passion in my life. I've been involved with legal costs from the beginning of doing my articles, um, and I feel like it's a subject that no one pays enough attention to because it's really important. And I mean, if you think about it, what is costs? It's the way we as attorneys make money. And pretty much you'll find out later that everything that has to do with professional negligence and getting into trouble with the law society, a lot of the time deals with money as well. So, from a studying point of view, I want you to do what I did, and that is have a look at the contents table for your actual notes, and you'll see we don't have a lot of pages to cover. So take this specific subject as one that you can really ace. So get all of these concepts into your mind, and once we've got them, we'll go through a couple of examples, and I promise you can be able to ace this guy. So what I'm going to do is, first of all, let me tell you, this is very odd for me to be taping myself giving a lecture. I love working off the energy of a class, and so it's going to be very strange to ask questions and not be able to get answers from you guys. So bear with me if I'm a little bit flustered, a little bit by doing it on tape, but we're going to get through this. And I'm sure when I mark your papers, we're going to see how you've aced it. What I am going to do is I'm going to go through each chapter as it goes in your book, and then we will do separate videos for each. Ones are where I need you to calculate things. And on that note, I want you to get a calculator that is a ridiculously simple calculator. So I'm showing you this calculator, and this is the kind of calculator I want you to have. Or even simpler than that, like the little guys that you get from the crazy store. Those scientific calculators where it's the second function cos and all those, it just creates confusion. So we're going to use the simplest calculator you can possibly find. Right, let's start with just going through the beginning part, which is really much like any other stuff, bit of an introduction. So we're on page 1 of your notes. And importantly is, if you look under sort of each section, you'll see what the student should be able to do. And when you've gone through that specific chapter when you're studying, go back and see if you can do what the students are required to do. And if you can do that, it's basically covered everything in that chapter. Right. So we're all aware of the fact that we have the Legal Practice Act. And the Legal Practice Act, while it's been around for a little bit now, seems to still be in its infancy stage, and there's a lot of sort of in-between things that aren't sorted out yet about the Legal Practice Act. And so with that, they actually make reference to it on page 1, and they say Section 35 of the Legal Practice Act refers to fees in respect of legal services. Until an investigation in terms of subsection 4 has been completed and the recommendations contained have been implemented by the ministers, fees in respect of litigation and non-litigious services rendered by legal practitioners will now be in accordance with the tariffs made by the Rules Board. Section 35 has not yet been implemented at the updating of the manual. However, students must be aware of the possibility that Section 35 can be implemented at some stage. So until such time as 35 is implemented, we're going to carry on with it the way we've always done it, with no changes, which is good for me, because I'm lecturing something I've lectured before. Right. So then, I think, what would law be without a bit of quotes? They refer to a quote by Lewis that deals with legal ethics. They say legal practice is not a suitable field in which to exercise a flair for the amassing of wealth, despite what is sometimes alleged to the contrary. The attorney who acquires riches also does so by investments and activities extraneous to his profession. Usually, however, legal practitioners still seldom acquire great wealth. Not something you want to hear when you're about to embark on a legal career, But I think it's important that we look at that and realize that this idea that all attorneys are these rich money grabbing individuals is not actually the case, and we don't want attorneys to be these money obsessed individuals. We need to play by the rules, and we're going to teach you the rules. Okay, so it's important that we know that an attorney must always charge fees. Okay, the only time you're not going to charge fees is when you're acting pro deo or pro amico. And what does that mean? Pro amico means you're a friend of the court. We know what pro bono means, which means we're doing something on a free basis. But in both of those circumstances, when you're doing something like that, you're going to have a nice agreement with the client so that no one comes back to bite anyone at a later stage, because the bottom line is that we have to charge a reasonable fee for professional services. We undertake to do for a legitimate fee for the duration of the professional relationship, and we don't take advantage of any client status. Now, that's quite important. If I see a person arrive in a Porsche Cayenne, that is my dog running around behind us. Please ignore it. If I see somebody arrive in a Porsche Cayenne, I'm not going to think, well, this client can afford considerably more fees and then charge them a higher amount. We're going to treat everybody the same, doesn't matter their status. Okay. During the course on legal costs, the broad outline of the principles applying to legal costs in South Africa will be discussed, and the emphasis will be on drawing and taxation of bills of costs in litigious matters. Okay. So that's going to come a little bit later. I want you to get a brief background as to the concepts of legal costs, and there's a couple of concepts that I need to understand before we can jump further. Okay, what are legal costs? The most crazy definition you've ever seen is found in your notes. It basically says costs for legal work done by a legal practitioner in the execution of the mandate. Okay, or it's payable in terms of a court order or an agreement. Okay, sounds pretty simple, but it's considerably more complicated. I've seen on numerous occasions how people who have been in the legal game for a long time don't understand the concept of legal costs, and because of that, they can cause a lot of drama for their own clients. And by drama, I mean not acting in the best interests of their clients. And you'll see as we progress through the notes how important it is to have a proper understanding of legal costs. Okay. Right, the first concept I'm going to need you to understand is the difference between litigious and non-litigious fees. And those are two branches of the law. And if we think about it, does every attorney always go to court? And the answer is no, because some attorneys are what we call litigators, who are in court all the time, and there are some attorneys who deal with drafting, conveyancing work, corporate drafting of contracts, lease agreements, and all the stuff that is outside of court. Now, it's important that we understand that there's a distinction between litigious work and non-litigious work, and that's vitally important for going ahead. Right, so why is it important to distinguish between litigious and non-litigious work is that different rules apply to them from a cost point of view. So non-litigious work effectively is governed by statutes. So for example, conveyancing matters, what we're allowed to charge and how you're allowed to charge for a conveyancing matter is governed by the Deeds Registries Act. No reference to court rules or anything like that. What are we allowed to charge in estate matters? That's governed by the estate legislation. And insolvency, what is the insolvency practitioner allowed to charge? That's also governed by the Insolvency Act. So where there are matters, like let's say, for example, drafting a lease agreement, there's no Lease Agreement Act, that sets out what a person's allowed to charge for a lease agreement. So if there is no tariff, then the council of each law society sets out some guidelines as to what a person is allowed to charge. So Let's think about this. Okay. If I have drafted a lease agreement and now I need to charge my client, first of all, I'm going to ask myself the question, is this litigious? Was I in court? No. So it falls under the non-litigious group. And if it's non-litigious, what am I allowed to charge? Is there an act that governs this? Nope. So what do? I look at my society's guidelines, and I'm then going to charge based on those guidelines. But what would the law be without a few exceptions? And those exceptions are things that are in court, matters that are in court, but that the law basically deals with as non-litigious. And those are some of the exceptions. And those are things like criminal matters, children's court matters, maintenance matters. These are all matters where there is no tariff in court that tells us what we're allowed to charge, and we then deal with it as though it's non-litigious. So it's in court, which was how I told you to distinguish between litigious and non-litigious, but these are examples of matters which fall outside of the litigious section, if you want to call it. So those matters, criminal matters, children's court matters, maintenance matters, those matters fall under the non-litigious group. And so when we're wanting to know what we can charge our client for those matters, we need to look at the guidelines that are set out by the Law Society. Right. When we have a civil litigious matter, how do we know what to charge? Here we base, the rules are all based on the tariffs. Now the tariffs come from legislation. They're in the back of your Magistrates Court Act or your High Court Act. You'll see that Rule 70 is the rule that deals with it in the High Court. They set out what we are allowed to charge. Now that's for litigious matters. So let's just recap what we've said. When we're dealing with non-litigious matters, what are we looking at? Non-litigious, we're looking at guidelines from our Law Society. And litigious matters, we are looking at the rules of court. And it makes kind of sense if you think about it, because we're in court. So court is going to tell us, well, not court, legislation, rules, the rules of court are basically going to tell us what we're allowed to charge. Okay, that's a very important distinction. The distinction being non-litigious work versus litigious work. But just to recap again, that remember we have those exceptions. There are some exceptions which look like they're litigious, but they're not. What are those examples? Things that are governed by statutes, criminal matters, children's court matters, maintenance matters. Those are things that look litigious, but are non-litigious. Right. There's a heading of balancing of duties. A legal practitioner has on the one hand a duty to their client, and on the other hand, we have the right to be able to charge for our services. I said to you right at the beginning that a lot of ethical ramifications come from not being able to understand the law of costs, and there's a case here that's cited. The conduct of a particular attorney was both unethical and wrongful, and it was further held that the attorney had an ethical as well as a duty towards a non-client. And that's important when it comes to cost orders and recovering costs on behalf of your client. In order to avoid a conflict of interest, a proper knowledge of the ethics, the rules and regulations regarding and governing legal costs is essential. Okay. The economics of an attorney's practice. Effectively, what they're saying is that what you charge is based on supply and demand. So as you charge for things, it can stimulate a more professional and superior legal services. But the Competition Commission has strongly recommended the attorney's freedom in determining their own fee structure. But there are restrictions which can be found in a number of statutes and regulations, which will be referred to later. We must at all times act on the instructions and in the best interest of the client, without regard to ourselves and within the restrictions in which we have been placed. They talk about a budget, and as an example E, about your monthly budget, but I think a lot of that is dealt with when you deal with practice management, which I'm sure you will. Okay. Ridiculously important is early advice to client and estimate of costs. I cannot tell you how many times somebody will send an email or make a call to my office and say they want, let's say, for example, they want to get divorced and they want to know how much is this going to cost me. And it's very difficult to give a cost estimate to a client because I may well send a letter to the opposition and the matter could be settled without even issuing a summons. I could send out a letter of demand on behalf of a client and the debtor could pay. Or the debtor wouldn't pay. We have to issue a summons. We get 3 or 4 returns of non-service because we can't find the guy. We've got to employ a tracing agent. Finally, when we do serve him, he enters an appearance to defend and the matter proceeds all the way to trial. Obviously, one is going to be a lot more expensive than the other. Now, very important that we also understand that the man on the street who is not a legal practitioner and doesn't have a legal costs course that they've done is always under the impression that when they're successful in any civil suit, that they will get their costs back from the other side. Now, yes, they do get costs, but this is a very important distinction that I need you to understand. And this is the distinction. What do we charge our client? We charge our client fees. How do we know what to charge our client? We enter into a fee agreement with that client that sets out, Mr. Client, me as the attorney will be charging you X, Y, Z. We get them to sign and we charge them in terms of that fee agreement. That is considered attorney and own client costs. Makes sense. It's the cost between an attorney and their own client. What's it based on? A fee agreement. Is there any reference to the rules there? Nope. So what does that mean? It means that as an attorney, I can charge based on my experience and my time of being an attorney and my experience in a certain field. I can charge 2,000 Rand an hour if I want to. And when the client signs an agreement with that charge, we are effectively entering into a fee agreement as to what I will be charging my client, and it is my attorney and own client costs. Right, so now let's use that as an example of me charging 2,000 Rand an hour to my client. Actually, no, let's use a better example. I agree with my client that I will be charging 100 Rand per letter. And let us say that this is a magistrate's court matter. When my client is successful, I will get a costs order. And what will that mean? That will mean that my client is not only entitled to whatever the capital, let's say, he sued for monies loaned and advanced. He's not only going to get the money that he loaned to the defendant, he's also going to have an order that says the defendant must pay all of my client's legal fees. Okay. But what will those legal fees be? Those legal fees are going to be based on the court tariff. And the court tariff is very different than attorney and own client fee agreement. That court tariff might say, for every letter sent, you can get 33 Rand. And that is a legitimate figure in the court tariff. So my client has paid me 100 Rand for every letter that I sent. But when we get the costs from the opposition, how much am I getting back? 33 Rand. So my client will be out of pocket for 67 Rand. And clients don't understand this. So it's ridiculously important that we explain to the client right from the beginning the difference behind what you will be paying me in terms of an attorney and own client fee agreement that they've agreed to, and when they're successful, what costs they will be able to recover from the opposition. Now, another quite big distinction, which I'm going to go into a lot more detail on later, is those costs that I said that we would be able to recover from the losing party are what we call party and party costs. Okay? Again, that makes sense between one party and another party. And party costs are the costs that are governed and regulated by the rules of court. No way around getting around that. So let's just recap what I've said. My client must be aware right at the beginning before we start that we have entered into a fee agreement and that he is liable to me for the costs by taking the matter all the way to trial based on the fee agreement at 100 Rand a letter, 2,000 Rand an hour for consultations and court time. Every telephone call is going to be 50 Rand, let's say, for example. All of these will be put down in your fee agreement and you're going to have your client sign it. Your client will continue paying you until the end of trial or until the trial in terms of that fee agreement. And they may have paid you 10,000 Rand by the time we get to trial. They win and they get their costs back. But what are those costs that they're getting back? They will be getting, the opposition will now be paying their party and party costs, which are governed by not the fee agreement between my client and myself. We're governed by the rules of court. And the rules of court have tariffs, and the tariffs set out what you're allowed to charge. And it may be that they only get 3, 4, maybe 5,000 Rand back. So they will be out of pocket by 5,000 Rand. Why do you think it's important to explain this to a client from the beginning? Well, quite obviously, if they're suing for 10,000 Rand and they're going to end up out of pocket by 10,000 Rand in costs, they need to know that to make an informed financial decision as to whether litigation is even worth their while. But most importantly is that at the end of the matter, when they think that they're going to get all their costs back and you do not get all their costs back, and for no fault of your own, but basically because of the rules of court, they're going to say you didn't explain that to them. So it's very important that from the beginning, we explain to a client the whole aspect of legal costs. I go so far as to put that into my fee agreement. I put an explanation in there and I make the client sign it so they can't come back at a later stage and say that I didn't explain it to them. Very important. We often hear people saying, I sued and I used this attorney, and at the end of the day, I didn't get any money back from the attorney and I ended up owing the attorney. Now, that's for the same reasons I've just explained, is that if there's this massive gap between what you paid, what the client paid you and what you were able to get back, it's going to have an upset client. With regards to cost estimates, we are actually supposed to be giving our clients an idea of what it's going to cost. It's an important practice that I use, that I deal with different sections of the law. So I'll say, right, for us to get to this point, this is what I anticipate it will cost. For us to get to the next point, this is what I anticipate it will cost, and so on and so on. So that at every stage, your client is well aware of what they're being charged for and what they can expect from a financial exposure point of view. Okay. Very important as well at the bottom is dealing with a mandate. And we all know that it's important to get a mandate in writing. And what is a mandate? It's what the client is expecting from you. Okay, so that you don't veer off and get something else they don't want. So a defined mandate, also what a mandate is an agreement between you and the client, as well as its termination must be clearly demarcated. It's advantageous to obtain a written mandate so the possibility of dispute is limited and cost implications are clarified. That's what I said to you, is that putting that whole cost issue, putting down exactly what you're going to be charged, then signing it, and nobody can come back at a later stage and say that it wasn't there. Particulars relating to fees and disbursements must be that will be levied. Payments for interim and final accounts, as well as the client's liability, should be clearly stipulated. Costs of a legal suit belong to the client, and the attorney has, to a limited extent, a lien on his client's claim for the costs in obtaining it. Okay, now that I just want to quickly double back on that. When a court awards your client costs, let's think about that logically. Whose costs are those? Those are the client's costs, not the attorney. The attorney will assist the client in getting those costs from the opposition. But when that money comes in, whose money is that? Not the attorney's. That's the client's money. Okay. The most important requirements for a written agreement are set out. There's case law. The fee agreement must be certain and not vague. The fee agreement and fee structure will have as its basis the principles that are set out in the tariff. And by that, I mean, if you look at the tariff sets out how much you're allowed to charge per letter, how much you're allowed to charge for drafting, how much you're allowed to charge for a telephone call, for court attendances. So they're saying when you set out your attorney and own client fee agreement, also sort of base it on that. You don't want to say for a divorce it's going to cost 3,000 rand, because that's ridiculous, because one divorce may last you 4 years of a lot of work, or another divorce could be on an unopposed basis. So rather set out that the client is well aware of what it's going to cost them. Okay. The client must confirm that the difference between party and party costs and attorney and own client costs have been explained to them, and that's what I explained to you guys. What my client is paying me versus when I get a costs order, what I'm allowed to get from the opposition. And that's party and party costs, which could be, like I said, 33 Rand a letter, but my client has paid me 100 Rand a letter. They need to understand that and agree to it. Okay. Taking a deposit. Well, good idea to take a deposit for a couple of reasons. First thing is, when I take a deposit, I am now 100% sure that my client can afford to pay for legal fees, because I don't want a situation where I've done a whole bunch of work, send them a bill, and they say they don't have money or they're unable to pay. So taking a deposit is a nice indication that your client is actually not only able, but willing to pay. Okay. What else is a good idea for taking a deposit? Well, I've got money available for when I have to pay the sheriff, for paying for the return of service for the summons, the registered mail charges. I'm not having to pay out of my pockets for disbursements. Okay, what's the most important thing about taking a deposit? Until you've done work, which you can recoup from that deposit, whose money is the deposit? It's your client's. So where does it go? Into your trust account. Okay. They deal with estimate of fees and disbursements again. And basically what I've said to you before is that it's very difficult to give an estimate of fees and disbursements to a client, but you should at least try. Okay. It's, for example, let's say for example, you're wanting to use a counsel or an advocate when we go to trial, you're going to know how much that counsel is going to charge. And because of that, you can sort of advise your client what's anticipated so they can start paying into your trust account so that when we need counsel, we have money available to pay counsel. You don't want to spring it 2 days before trial from client that, oh, listen, by the way, client, it's going to cost us 15,000 Rand for counsel to be there. I want 15,000 Rand. And they've got 2 days to be able to find it. So it's important, if you want to run a smooth practice, and you don't want to get on the wrong side of a client when it comes to money, is that you're just constantly keeping them updated as to what's required. Okay, I'm going to pause a little bit because I need to get a piece of paper, because we're going to deal with contingency fees now. And this is the most exciting and topical point of the course. I love it. And I'll see you in well, I suppose I'm not going to even see you in a minute because I'm going to pause and start again. But let me go and get some paper and a pen. Okay, so we're back. I'm going to try the hardest I can to try and show you what I'm doing on the paper while holding the phone. But let's talk about contingency fees. Right. Let's say an unemployed man is walking down the road and he falls into a massive pothole and he breaks his leg so badly that his leg has to be amputated. I mean, worst case scenario. Now that's wrong. Don't you agree? He needs to sue somebody because there was some sort of negligence on somebody's part which allowed him to fall in a hole. But he wouldn't be able to pay for an attorney's legal fees. So years and years ago, before it was all regulated, there was an agreement called the Champatty Agreement, okay? And that basically said that when when something like that happened and you can't afford legal fees, you can enter into an agreement with your client, with your attorney, that the attorney is not going to charge you anything, so you won't be paying a lawyer to act for you, but when you're successful, the lawyer is going to take a portion of the monies. Makes me think of RAF matters, medical negligence matters. I mean, these are matters you're all aware of, and you know somebody who's entered into a contingency fee agreement with an attorney. Then it needed to be regulated because it got massively abused. And I'm sure each one of you can have or say some sort of story about a client that was abused by an attorney not correctly dealing or unfairly dealing with a contingency fee agreement. So then the Contingency Fee Agreements Act came into operation, and it set out what we're allowed to do as attorneys. And basically, everyone is stuck on this 25%, and we all think that we're allowed to take 25% of what a client gets. Full stop. It's not the case, okay? And this is where it becomes really important. The rationale or the calculation that the Contingency Fees Agreement Act tells us is the following. It says, an attorney doesn't charge their client fees, but if they are successful, what they are allowed is their normal fee times 2